And the last and most vague government interest proposed by proponents was recognizing a legal distinction between same-sex and opposite-sex couples. Now, first of all, I would point out that it's not clear what, if any, distinction could be found that would justify preventing same-sex couples from marrying. But from a legal point of view, evidence shows conclusively that moral and religious views form the only basis for a belief that same-sex couples are different from opposite-sex couples. And if you look through the trial, if you look at the evidence, if you look at the testimony, that seems very clearly borne out. Now, I want to talk a little bit about some of the history that came out here. Most of this is mentioned in the various notations. If you ever get a chance to read the actual documentation of Barry v. Schwarzenegger, it's very interesting. And I just wanted to take a few selections here to give you a sense of society's reactions, society's feelings about homosexuals, to place this issue in a cultural context. Assistant Attorney General of California in 1949. The sex pervert, in his more innocuous form, is too frequently regarded as merely a queer individual who never hurts anyone but himself. All too often, we lose sight of the fact that the homosexual is an inveterate seducer of the young of both sexes and is ever seeking for younger victims. A year later, in 1950, Coronet magazine, a very widely read publication, in the fall of 1950 said, once a man assumes the role of homosexual, he often throws off all moral restraints. Same-sex male deviants do not stop with infecting their often innocent partners. They descended through perversions to other forms of depravity, such as drug addiction, burglary, sadism, and even murder. More recently, 1969, everything you ever always wanted to know about sex but were afraid to ask cites this paragraph. What about all of the homosexuals who lived together happily for years? What about them? They are mighty rare birds among the homosexual flock. Moreover, the happy part remains to be seen. The bitterest argument between husband and wife is a passionate love sonnet, by comparison with the dialogue between a butch and his queen. Live together, yes. Happily? Hardly. Now, we like to think that we're more enlightened. I would hope that most of the people in this room, everyone in this room, would find these sentiments repugnant, obviously false. And it's easy to say that 30 years later, 40 years later, 50 years later, 60 years later. But what are people going to be saying about this issue 30, 40, 50, 60 years from now? You know, there are a lot of people out there who would say everything I just read is disgusting and false and vile, but we should draw the line right here. We can't let them get married. We can't pervert the definition of marriage. And we're living in a time and a place where it's socially acceptable to have that opinion. Now, personally, I'd like to see that stop being the case as soon as possible, because I don't think that is a viewpoint that ought to be socially acceptable, but that's not for me to decide. What I want to challenge you guys to think about is, you know, is this a legitimate point of contention, or is this just another manifestation of societal bigotry that's too slow to change? Now, more recently than any of those other entries, in 1992, another statewide referendum known as Amendment 2 was added to the Constitution of the state of Colorado, explicitly removing sexual orientation from discrimination protection. In other words, a ballot initiative voted on by the people in the state of Colorado decided that it was made it unconstitutional in the Colorado Constitution to protect homosexuals and bisexuals from discrimination in housing, education, employment, public accommodations, health and welfare services, and various other transactions and activities. This is way beyond saying, you know, we can't redefine marriage. As recently as '92, people voted on and passed an amendment saying we they can't be protected from any discrimination. And this amendment, until it was overturned in the U.S. Supreme Court in 1996, in other words, it stood on the book for 4 years before it was overturned in the Supreme Court, precluded legislative, judicial, and executive action to protect homosexuals from discrimination. That's the society that we're in. We are the inheritors of that legacy. That's the context this comes up in. So think about that when you think about the question of how legitimate is the debate about gay marriage. Any thoughts about that at all? Anyone? Go ahead.
Where in any statute, federal or state, is marriage a given right?
This, this could be a rabbit trail that we could go down and spend an hour talking about, but it's important to notice that Proposition 8, the proponents of Proposition 8 in Perry v. Schwarzenegger, quote unquote, do not dispute that marriage is a fundamental right, which is fine because there is no dispute there. Over and over and over again in case law, marriage has been identified as a fundamental right. Marital privacy has been respected as a fundamental right. The Fifth Amendment protects spouses from thank you, against each other. How can marriage not be? Think about what marriage is. As a heterosexual, I assume that you value your right to get married, right? To enjoy all of the material and immaterial benefits of marriage, the stability.
For myself, I see it as a privilege, as the fact that there is no, or it may be accepted as a right, but it can be, somebody can make the case that if it's not explicitly given, written down in law, or that it, it's not a hard and fast right, so to speak.
Well, let's say just for the sake of argument that I were to agree with you that marriage is not protected. Let's say it was a privilege. How then does that make it fair or legitimate to explicitly exclude same-sex couples from that privilege?
There are ways for people to deny privileges, and some will say that that's not, it's not fair for other people to have certain privileges removed for and things don't always match up the way that they think you should. I'm just saying, I'm not saying I necessarily agree with it, but I'm saying.
So life is not fair, is what you're saying.
Life's never been fair.
What does that have to do with this?
Yeah.
I don't know either. Keith, want to talk a little bit about some of these reactions?
I'm going to start off with a video of ProfMTH. He's actually a legal professor at a different college that gets involved in some issues that we're talking about. But I'm just going to recap of what Hilary went over. This is the equal protection and due process. This is why we're here talking about this. And this is Judge Walker. Throughout our presentations, we'll probably mention in quotes from legal cases. This is the judge who struck down the Proposition 8 in California. And I just want to mention that a lot of people who found out about this in the news, they kind of went at him in a personal way rather than a professional legal way. So they called him biased to be in himself. So they said that that's why he overturned this law of Proposition. It was a majority. There was a majority of people who voted for it. We'll point out later through ProfMTH's video on YouTube. People know you might have a majority of people voting for something. That is the democratic process, but we live in a constitutional republic which has representation. So even though you vote one way, you can get presidents who didn't deem it as well, or you can get laws that pass through. But it doesn't make it right or in the terms of the constitutional republic. So to
Since the publication of Judge Walker's ruling, many of the more prominent, bigoted, and bitter supporters of Proposition 8 have tried to call the merits of the decision into question by pointing out that Judge Walker is a homosexual. Oh my God. For example, Christian right leader Charles Colson posted the following on his website, breakpoint.org, quote, "Inasmuch as Walker is one of the few openly gay federal judges, maybe his decision shouldn't shock us." On its website, the so-called National Organization for Marriage screeched, quote, "An openly gay judge in San Francisco ruled that his imperial voice trumps the voice of the people." Get it? Imperial Empress Queen. Tony Perkins of the Family Research Council.
One judge who thinks he knows, a district level judge, and an openly homosexual judge at that.
Pat Robertson.
Judicial activist, one homosexual judge. One homosexual judge.
Old Pat Buchanan.
Oh, well, yeah.
And he happened to be gay. That might have had something
Has
to do
nothing to
with
do
it.
with it.
William Lane Craig.
And Judge Walker, who is one of 3 openly homosexual judges, federal judges in the United States, ruled in favor of the plaintiffs.
By the way, I posted a question about this on Dr. Craig's website to see the answers. It's disheartening to see comments on Dr. Craig's website defending this blatant ad hominem and bigotry, alleging that a gay judge's sexual orientation, quote, might cloud his thinking, and that a, quote, homosexual has a vested interest in the outcome of this case, and therefore a, quote, conflict of interest that necessarily renders him or her unable to judge impartially. Not that long ago in our history, bigots used to say precisely the same things about female and African American judges presiding over employment discrimination and other civil rights cases. Bigotry never really changes.
All right, so that video right there, you can see all the different people. You've got your Christian groups and your more conservative groups, people. I mean, personally, I am conservative, but that gets regardless. My speech. You can see how they went out in a personal way, saying that he was impartial and totally biased, but you know, that's why we're having this discussion. There's other countries out there, like Spain and France, that have, you know, already solved this problem with, you know, gender equality as it pertains to this class and sexual orientation. But you know, the United States, we kind of thought it was, you know, leading the world as number one in this and that technology, you know, equal rights, but yet we still have this conversation. So you can see how we can call each other bigots based on, you know, our personal belief of how something should be. Or even the way that we believe the law should be written, that's up to the Supreme Court justices, because they have, you know, that academic standard to make those judgments. But we shouldn't get into the habit of legislating reality. You can see their bodily reactions, you know, she's shaking her head like, oh my gosh, she's gay. You could get some other political pundits out there saying, you know, this guy's gay, he's going to ruin your children's future, he's going to ruin this, he's going to ruin that. It's going to take an institutionalized version of marriage and kind of like take it off its hinge. But that's kind of a good exercise for us to go through this, because we don't know what's perfect, we all have our own view of what we believe to be right. But, so I'm going to get into the next video, which is face the Grecian, and just keep in mind that we're in a constitutional republic, and we're going to emphasize this equality issue in the due process law as it pertains to judges. So this is the attorney and plaintiff for Perry versus Schwarzenegger, David Police. This is David Police, and he's going to give a clear overview about the principle and how it applies to what we're talking about.
Well, it's easy to sit around and debate and throw around opinions, appeal to people's fear and prejudice, cite studies that either don't exist or don't say what you say they do. In a court of law, you've got to come in and you've got to support those opinions. You've got to